So invention has two, well, the law looks at invention as having two stages. One is conception, and then the second is reduction to practice. And what do we mean by conception? That's actually when the idea comes to, when you conceive of the, when you think of the invention in your mind, when you can draw it down on paper. So conception would be, say with this group, if you, I don't know, we have people working on medical devices or something that's closer to it, or say a new chip or processor or something I don't know much about. But if you have an idea in your mind about how you're going to rework that device to make it better, that would be the conception. Say you wrote it down in your laboratory notebook. That would be conception of the idea. And then reduction to practice is actually maybe building a prototype and showing that it works as you envisioned it to work. So when the law looks at inventorship and who's an inventor, it's determined with respect to the invention as claims. So has anyone in here been involved in a patent application or know what claims are, per se? 1, 2, you have. So for those of you who have, and who've seen a patent, have people seen patents or a little bit more? So you know at the end, so most of you or some of you know that at the end of the patent, there's a group of numbered sentences. And those are the claims. And that's whatever you've said in your spec before, or whatever you've said in your application before. At the end, there are claims. And the claims are what you're really saying is your new invention. And so when we're trying to figure out who an inventor is, we're not going to look at all the great work that went into the application or the rest of this patent application. What we're going to look at is the claims and who conceived of the invention being claimed. And what the law looks at is conception is really important and determining inventorship, and reduction to practice is really not that important. And so I have down here the critical question to ask is, who conceived of the invention as claimed? And that's sort of a recurring theme. It really depends on what you're claiming, not necessarily what you said in your patent application or all the other ideas that you might have written down in your patent application. So we can have, a lot of times if you have a group of people working on something that goes into a patent application or an idea that goes into a patent application, you can sometimes divide them up into 3 different categories or groups of people. Contributors to the basic idea of the invention, contributors of labor only, and then other people who might not fit into those 2 neat categories. And so again, because it's really dependent on the invention as claimed and who conceived of the invention as claimed, if you can figure out those people who contributed to the invention as claimed, they're clearly going to be inventors. So if you can look at lab notebooks or something like that of people and you can see the idea written down and they were the first person to put all those ideas down on paper and that ultimately ended up, those features ended up in the claims, clearly they're going to be an inventor when you're looking at the claims. Contributors of labor only. This might be a situation where you have a group of people who have come up with the idea and then they recruit some other people to maybe make a prototype of what they've conceived of, and they give them a lot of instructions on how to make that prototype. So really all the laborers are doing is carrying out the explicit instructions of the people who are telling them what the prototype is supposed to look like. Those would be people who maybe did a lot of work in reducing it to practice because it wasn't an easy thing to do in making that prototype, but they won't be inventors because they didn't contribute to the conception of the invention. And then we've got the other people who are also involved in the process, but unless we can tie them somehow to the conception of the invention as claimed, and again as claimed, they aren't going to be inventors no matter how hard they worked on the whole process. So I guess some of the things that you want to just remember about inventorship is it's not the same as authorship. And you can't be an inventor just because you worked really hard on a project. You have to have made some contribution to the idea of the invention, not just working on it and carrying out what someone else's idea was. And it can seem unfair sometimes because it could amount to the fact that the project wouldn't have gone forward but for all your hard work, but for making it, but for reducing it to practice. But unless you can tie your contributions into the basic conception of something being claimed, you're not going to be an inventor. And then I just wanted to point out that ordering of inventors really has no legal impact. So while in papers it can have a big impact, there's really no reason. There's no legal reason for having any kind of order of inventorship. So oftentimes people will just list them alphabetically, or maybe the person that they've interacted with most in preparing the application will be listed first. But if your group of inventors wants a different order, it's probably okay. And then inventorship errors, if there's an error made in determining inventorship at any point in time, you can correct it. It gets a little harder after the patent is issued because you have to provide a little more evidence to the patent office to correct it, but you can correct it at any time. It is a little bit different from a typical company in that inventorship by OTL, if you're determined to be an inventor, as I understand it, can carry different compensation if your invention is licensed. So although all ownership rights reside with Stanford, nonetheless it can be important to determine inventorship from the get-go in some of these situations, because a lot of times, people will be thinking that they should be an inventor, maybe just because they don't know what inventorship is really all about and what the law is about. It's not a intuitive thing. You think if you did a lot of work on something and you and it wouldn't have gone forward but for your contributions, you should be an inventor. But that's really not what the law requires or what the law says. So sometimes it is helpful when you're working together as a group when you are working with an attorney on your patent application here at Stanford, if the attorney doesn't ask you about the inventorship, or at least preliminary go through it, make sure that everyone in the group is happy with it, and maybe ask your attorney to go over it with you at least a little bit, so you can have a determination at the get-go about inventorship, because it is important in this setting, because that's how, if your invention is ultimately licensed, that plays a part in how the royalties are distributed.